Hello there, my name is Terry Gorry and I'm a solicitor in Enfield in County Meath. I've received quite a few questions about what the new procedure is for going bankrupt in Ireland. The situation is that there's a new bankruptcy provision made in the Personal Insolvency Act of 2012, and it recently, only a few weeks ago there in December of 2013, was signed into law by the Minister for Justice. So this video is just going to take a look at what's involved in going bankrupt in 2014 with the new law in place. You might be thinking about going bankrupt. It's an option for some people. It's not an option for other people. You should really firstly visit a PIP and secondly visit a solicitor in order just to be sure that it's for you. But anyway, we'll just take a look at the how it's going to work. This video now is about a debtor's bankruptcy, and a debtor's bankruptcy is where the person who owes the money is choosing to go bankrupt. In other words, you may have big debts and you may be deciding that you are going to go bankrupt. A creditor's bankruptcy then, on the other hand, is where a creditor of yours, and that's the person to whom you owe money, chooses to apply to have you made bankrupt. That's a slightly different procedure, but this one is where you choose yourself to go bankrupt. You see this as the best or perhaps only option to get some peace of mind and take care of a lot of debts that you may have. The first steps in the bankruptcy procedure, well, before you apply for bankruptcy at all, you need to explore the alternative solutions available to you, which are provided in the Personal Insolvency Act of 2012. And these solutions are a debt settlement arrangement or a personal insolvency arrangement. You do have to explore these options, because ultimately when you do apply for bankruptcy, you will have to swear an affidavit that you have looked at those options and they're not suitable for you for one reason or another. And that's why I advised at the outset of the video that you would want to visit a PIP first to see that bankruptcy is suitable and is your only option. Do you need a solicitor then to apply for bankruptcy? Strictly speaking, no, you don't. But you probably would be well advised to engage one, because firstly it's a High Court application by way of a petition which has to be drafted, and then it's verified by an affidavit and a statement of affairs. Again, there's a bit of drafting involved there, not a whole lot. The statement of affairs is relatively straightforward, but probably most people are not comfortable going into court, and certainly probably wouldn't be comfortable going into the High Court. But it is possible to do it yourself. You also, though, would, if you're going to visit a solicitor, you would want to just seek legal advice to confirm that bankruptcy is the right option for you. And then you may also have some questions about the consequences of bankruptcy, what happens afterwards, and what happens to bank accounts, to maybe company directorships, to the family home, perhaps you're in a partnership, and so on. So you may well have questions, and you're probably as well off to seek legal advice to have those questions answered and to bring your application. But as I say, it's a matter for yourself. There are two key offices then that you need to be aware of in relation to bankruptcy. One is the office of the examiner of the High Court, because your application for a bankruptcy order is filed in this office in the first instance, and it's an office of the High Court. The second office you need to be aware of, or you will become familiar with if you're going the bankruptcy route, is the official assignee's office. After your bankruptcy order is granted, you will deal with the official assignee's office. The official assignee is an independent statutory officer of court who administers your estate once you have been declared bankrupt. What are the consequences of bankruptcy? Well, the main consequences of bankruptcy are that your debts are wiped out. In addition to that, all of your property transfers to the official assignee. The only assets that do not transfer to the official assignee are essential assets up to a value of €6,000, including vehicles, or more if the High Court allows. So the High Court has to approve the retention of assets. You're discharged from bankruptcy after 3 years. You must contribute from your surplus income, if you have any surplus income, towards your debts for up to 5 years. The official assignee receives and deals with the claims of your creditors. So your creditors can no longer contact you, they contact the official assignee. And the official assignee then administers your estate. To be eligible then for bankruptcy, well, you must fulfill some conditions. clearly you must be insolvent. Now this must be stating the obvious, but you do have to be insolvent. You must lodge then €650 with the Insolvency Service of Ireland. You will have to swear an affidavit that you've made reasonable efforts to use the alternative debt settlement arrangements open to you. They are the debt settlement arrangement, or debt settlement situation, and the personal insolvency arrangement. They are provided for in the Personal Insolvency Act of 2012. Your debts then must exceed your assets by more than €20,000, and you must then present a statement of affairs setting out your financial position. You must also then, as referred to already, prepare a petition for bankruptcy. This petition will go to the High Court. That will be your application to become a bankrupt. As I say, the fees for bankruptcy, well, you need to pay €650 to the Insolvency Service of Ireland. There's stamp duty then on your High Court petition and affidavit. That should come to €102.50. Currently there's an advertising fee. You have to advertise your proposed bankruptcy in a national newspaper. An approximate fee for this would be €500. However, this is almost certain to change, because the Companies Miscellaneous Provisions Bill of 2013, when it's passed into law, will do away with the requirement for advertising in a national newspaper. So that €500 approximately should be gone. Your duties then in relation to your bankruptcy, well, firstly you have to attend the High Court on the day your application for bankruptcy is listed. You'll have to attend again on the statutory court sitting date. You also have to cooperate fully with the official assignee and attend the Bankruptcy Division of the Personal Insolvency Service of Ireland on the day that you are made bankrupt. You'll also have to attend for interview with the official assignee's office. After bankruptcy then, well, the official assignee will look for a contribution from your surplus income, if you have any, after deduction of reasonable living expenses. The reasonable living expenses are those that are set out on the Insolvency Service of Ireland website. They have, I think, a booklet or some sort of a document which sets out what they would consider to be reasonable living expenses. Your pension is not transferred to the official assignee, so if you're lucky enough to have a good pension, well, you'll hold on to it and won't be affected. A lot of people ask, what is the situation in relation to the family home in bankruptcy? Well, your share of the family home will transfer to the official assignee. You may be able to agree, though, a schedule of mortgage repayments with your bank, provided the official assignee agrees that these payments are within reasonable living expenses. The official assignee cannot sell the family home without first obtaining the consent of the High Court. Just to go back there to the reasonable living expenses and agreeing a schedule of mortgage repayments with your bank, it has to be reasonable. In other words, if you wish to pay a mortgage for a property, then the official assignee will allow that, provided they are reasonable. That would not cover, for example, a €2 million pile in the countryside or in Dublin 4 or whatever. Yeah, you do have to be reasonable, but if you are reasonable, well then you will be allowed, according to the official assignee, to make mortgage repayments. The High Court will consider each case on its merits, and it will look at your creditors, your spouses or civil partners' situation, and your dependents. If there is equity in the family home, in other words, it's not in negative equity, the official assignee will seek to sell his share to your spouse or civil partner. If there's no equity in the house, well then the official assignee will consider the sale of his share to your spouse or civil partner as well. That's really a matter for the official assignee, and it will depend on whether there's negative equity or equity in your property. You should be discharged after 3 years. It could be extended, this period, if you don't cooperate with the official assignee, or if you fail to disclose all of your assets and property. However, if you come to the procedure with clean hands, as it were, you should be discharged after 3 years. There are my contact details there. My name is Terry Gorry, I'm a solicitor, Enfield, County Meath. You can contact me on those phone numbers or the email address you see on the screen. Thanks for watching.